I'm just gonna start back with the question that I asked Brian, and I apologize for the people who were on here a second ago and heard this already, but we're talking about timing, and most organizations don't think about the timing as they sort of go through the business of managing their people, and it comes up in bad ways, and sometimes it looks really bad. How can I sort of globally say the law thinks about timing of employer decisions?
Um, Thank you, Natalie. I think the word you're looking for is temporal proximity, or I guess the phrase you're looking for is temporal proximity. And for to translate that from legalese, it's the time between a protected activity and a employment decision. So under the law, we're what's illegal is an adverse action. And the temporal proximity between, say, an FMLA leave request and a layoff can be an element of the case. And what you're looking at here is direct versus circumstantial evidence. And so circumstantial evidence is what most cases rely on. Very rarely do we see an email or anything in writing that says, we're firing this person because they took FMLA leave or because they requested maternity leave. More often than not, it is a decision that's made, and the decision maker may not even know that a person has requested leave, but for some reason, the supervisor who's making a decision and HR didn't communicate that there was a leave request, and that employee gets grouped with the other employees. And so it might not have intentionally been a discriminatory decision or retaliatory decision, but the way it looks is that way.
Okay, so Brian, and maybe Amber, I'll even include you to in this next question. What claims get triggered most often by timing issues, right? Because what's playing in my head is the knowledge that on the employer side, and Amber, you can probably speak to this, but it might take us 6 weeks to make the finalization and the next steps and the rollout of a decision to take an employment action, a termination, a reduction in time, whatever demotion, whatever it is. We might have taken 6 months um, to make that decision, but the employee only sees it in the moment. So Brian and maybe Amber chime in too. What are the claims or the triggers that most often come up when we're talking about timing issues?
Yeah, this is a fact pattern that comes up quite a bit for us. What'll happen is a decision to lay off maybe a specific employee or to terminate that employee for cause has been made, and they don't actually know when it was made. So they kind of sense that it's coming, and they will maybe request FMLA leave or request a reasonable accommodation for a disability, and so they think they're being clever, and all the while we know we made the decision much sooner than it was communicated to the employee, but that doesn't prevent a lawsuit or a demand letter from an employee's attorney, because on the surface it looks like a really big gotcha when the temporal proximity in time is close. And so employees, they talk to Chat GPT and they talk to lawyers, and they're getting clever about making requests to set up a retaliation claim.
All right, Amber, you want to chime in to interrupt the Brian show a touch?
Sure. So I think I'd only mention, things around, he mentioned ADA, also mentioned FMLA, anything along Title VII as well. So that includes harassment if they're participating in an investigation, workers' comp claims, and accommodation and leave. So all of those things, if you have an employee participating in any of those, just start documenting accordingly.
Yeah, documenting even your own behaviors, not just the employee behaviors. We are thinking about, we are looking at, we are analyzing this decision. All right, Brian, talk to me.
I was going to just add also, you didn't call on me, but like Amber just kind of specified the world of protected activities, there's also an entire world of employment decisions or employment actions that can also be problematic for employers when the temporal proximity can be demonstrated by the employee. And that can include, and Natalie, you kind of rattled off some of these things earlier too, but things like a demotion decision, to put them on a PIP, to discipline them in any kind of way, to change their shift, to change their location, remove their ability to work remote. Like there's a whole world of employment decisions upon which similar types of claims that Brian walked through can be brought as well.
Sort of the thing that we measure it by.
Yeah. Yes.
All right. Yeah. And yeah, good point. We were just kind of glossing over that. Brian, talk to me though, if I can get back to sort of the beginning of this engagement, FMLA. Can you talk to me about FMLA retaliation and interference? They sound pretty similar, but they're really, really not. What is the practical difference for employers, particularly employers who think they're being helpful?
Mm. Yes, so when an employee mentions medical leave, they don't have to use the magic words from the Medical Leave Act or FMLA. It's the employer's obligation to tell them about that leave. And FMLA interference occurs when you restrict, hinder, or deny their right to take leave. And retaliation occurs when there is more of a mental component to, because of their leave, you take some adverse action. And so that's really the distinction. Although in practice, it it doesn't it doesn't make a difference because they're both illegal.
Yeah. Lindsay, sorry, coming to you without warning. Talk to me about the ease of, because you're an investigator and you
Mm-hmm.
investigate employee complaints about things like this. I know that you can answer this question for me. Talk to me about how easy it is to measure, how easy it is to investigate and corroborate or not an allegation of retaliation versus an allegation of the underlying claim. I mean,
Oh, the retaliation component is like, especially in the instance in which you have temporal proximity, like, that's very plain to see, right? And it's obvious to, or the tendency is the instinctual human nature, or instinctual human nature is to infer causation from the fact that two things coincide in time. And so that is much easier for an employee or a former employee to demonstrate to a judge, jury, investigator than the underlying claim, which might be, I tried to take FMLA leave and they got in my way of doing that. Or it might be they didn't give me a proper ADA accommodation, or I was subjected to decades worth of harassment and discrimination. And those claims are much harder for an employee to establish, especially in the absence of an investigation, which happens actually more routinely than we'd like to see. And a failure to investigate sometimes is part of an underlying claim too. And so when that temporal proximity, that timing exists, the retaliation claim, I don't want to say it's a slam dunk, because employers have the opportunity, of course, to defend themselves, and it's why we're in business. But it makes that component of their claim so much easier.
yeah, it's
And
that inference of causation.
Yes.
That's good phraseology. Because a lot of times what we end up saying, team, isn't it, is that, I don't know, that smells bad. Or, oh,
Yes.
that kind of looks,
Like
that
maybe you can
timeline
do
looks
that.
bad.
Yeah, maybe you can do that legally, but should you?
Yeah.
Yeah.
and many of my our colleagues on the other side of the aisle that represent employees, they don't even take regular discrimination cases. They are only looking at retaliation cases because they're just so much easier to prove. And because there's no mental mens rea requirement, there's no
Yeah. Intent you
thought.
have to establish.
Yeah.
Establish.
Well, and I think that plays out for the reporting that we see. I mean, I think for almost the entire, I think I remember, Lindsay, when we were we were professional babies. We started seeing EEOC reporting, and I remember there was a big to-do about how it was shocking that all of a sudden retaliation claims were outpacing discrimination claims, but it sure isn't shocking anymore. The claim is so much easier to prove, and so because it's easier to prove, that's the piece that gets proven so very often in the EEOC allegations that get reported to us. And so it doesn't matter if the underlying claim is corroborated or not, the retaliation is easy. All right, let's shift gears only slightly. So still discussing FMLA, Amber, but I'm going to go to you. From a procedural standpoint, excuse me, from an FMLA procedural standpoint, what are an employer's obligations once leave request does come in? What do we need to be doing before any decisions are made?
I think I want to just back up a second and say, you need to confirm whether FMLA applies to your company first. And so
Yeah.
if you're a private employer, you have 50 or more employees within a 75-mile radius, then that's probably going to apply. And then in terms of the employee, if you determine that you have to comply with FMLA for your company, then they have to be employed for at least 12 months and a certain number, 1,250 hours during the previous 12 months. So I think once we have that basis down, we can go into more of the procedural in regards to, what reasons they're asking, whether it's their own serious health condition, caring for a spouse, a child, adoption, a parent with a serious health condition, or some military leave as well. So once we've kind of established the baseline there, you're going to want to provide a eligibility and rights and responsibilities notice. You can find these online and they're easily available. I would do that immediately, and then you can obtain certification if you do that. Make sure you're treating everyone, the same in that regard. Then you provide a designation notice within 5 business days. So you're going to want to do that. Make sure to let them know if this leave is approved, if this leave is not approved. And then, of course, document. We'll say this over and over probably, but just document, make sure managers understand employment decisions in this period are important to watch out for. And everyone's aware to the extent they need to be aware of it.
Hey Brian, how often do you deal with with claims that involve employers who did what Amber just said?
The single biggest issue for employers is failure in documentation. If you have a policy that's not being followed in practice, update your policy to match what you do. But employees' attorneys are out there looking for not following a policy or procedure that you have. But documentation is more important than actually following the policy or procedure. It's the single most important thing you can do is contemporaneous documentation. And that can be as simple as emailing yourself a reason why a decision was made because it's time stamped and date stamped. And we know that that's what happened on that date. And it's really hard to dispute that.
So to summarize, when clients do what Amber just said, Brian doesn't see that work. All right, Amber, I'm going to stick with you, but then Lindsay, get ready to jump in here. What happens when an employer terminates someone, puts them on a PIP, changes their schedule, and the week that they come back from leave? Like, what happens then?
The the week okay. Sorry, I was thinking. Okay. So when they come and they have reinstatement rights according to FMLA. That's part of FMLA. So, you need to put them in the same or an equivalent position. And if you want to issue a PIP at that point, change responsibilities, terminate employment immediately after. Again, document showing the issues existed before the leave. If you don't have a lot of documentation, which is what you see we talked about earlier, they existed, but it's not clearly documented before. Document those, and then, the biggest risk, like we've said, is there's no clear record of the decision-making process and how you came to that. So yeah.
Lindsay, talk to me about the humanness of being put on a PIP the week you come back from, say, maternity leave or the week you come
Well,
back from medical leave.
it go, if the employer doesn't do the things that Amber just kind of itemized, an employee returning from protected leave is going to, by human nature, conclude that they have been put on that PIP or have been otherwise disciplined because of their protected medical leave. And that creates that suspicious timing we talked about earlier. And they may or may not pursue a claim. They may or may not file a complaint. What I'm surprisingly seeing more and more is that employees, instead of first making a complaint with their employer, going to their HR, talking to their manager, what have you, and giving the employer an opportunity to properly investigate the claim they're making, they'll go straight to an attorney, or they'll go straight to the labor board, or the TWC. And the employer, meanwhile, oftentimes, especially if the process for returning an employee to work doesn't include a lot of communication between HR and the managers who are returning the employees. A lot of times the employer is totally sideswiped, for better or for worse. And so it's remarkable to me that we're seeing employees increasingly bypass HR and their managers. And as a person who does culture work and cares, we all care about employees in these environments, but who kind of thinks from an employee first perspective in a lot of ways. I think about, what does that say about your culture, that they don't trust HR enough to take that complaint, or they don't think anything will get done, or that sort of thing. And so if you properly return the employee and you properly manage their leave in the ways, and you document it properly in the ways that Amber's talking about, you can go a long way toward establishing that trust, so that we don't end up in a situation where the complaint could have been handled at the lowest level and instead has been escalated because you created a suspicious timing situation.
Brian, I'm going to jump over to you a bit unscripted, and I apologize. I do see my Wi-Fi is a bit iffy. What do you do? Because to Lindsay's point, people are bypassing HR. But one of the things she didn't say that I think we're seeing so much is they're bypassing HR because ChatGPT told them to.
Oh, I guess that's true
So
too.
what do you think about when an employee just jumps HR and goes straight to the TWC or straight to hiring a lawyer? And actually, probably the people that are going to GPT are not hiring lawyers, but goes right to the EOC or TWC or, workforce board.
Yes, so under the Americans with Disabilities Act, you are required to engage in the interactive process. And what we usually see is whenever that process breaks down, the party who caused the breakdown is the one who loses. So if the company declines to continue the conversation and terminates the employee, it's usually the company that's going to get caught holding the hot potato. On the other hand, if the employee doesn't give the company a chance to address their concerns, oftentimes the EEOC or the Texas Workforce Commission will throw that employee's case out, because you do have an obligation, both parties do. And so the one who stops talking first generally loses.
I'm glad I punted that to you, Brian, because we are going to move the pit that set us up perfectly for the next segment that we laid out here. Amber, walk us through what the ADA interactive process requires, the actual steps. We're talking about timing in this call. So what are the actual steps that the ADA in particular calls us out to do?
Sure. So first, you're going to acknowledge the request. And just like Brian said, you don't have to say, I need a accommodation. You don't have to use those exact words. If you know, and so I think that's why education, training on things of what qualifies as an accommodation, what conditions can qualify, which I'll go through in a second. But you want to acknowledge it. You want to meet with the employee as quickly as possible. I would say within the next, depending on what it is, 2 to 3 days at most. Meet with the employee, understand what their limitation is, what the workplace barriers are that are involved. Gather any documentation. Sometimes you might need some medical documentation, sometimes you may not. And then you're going to go back and you're going to evaluate the reasonable accommodation options. So throughout this process, you document when you met with them. Sometimes you might have a accommodation request sheet at your company, utilizing that. And then make a decision based on the essential functions of the position and if it creates a undue hardship. So, if you can feasibly do what they're asking for, you need to be able to accommodate that individual and start that process. Make sure to communicate that in writing, whether it's email the employee, this is what we can do for you, this is the amount of time that we'll do it for, and then implement and also check in with that employee because some of the things that you don't see things that, you think, oh, maybe they broke their leg, they need some kind of accommodation. But there's a lot of mental health conditions that have come up. Neurodiversity has come up, things like that, where you're not going to see it. You're not going to know if it's working. So that interactive process that Brian mentioned, just going back and checking in, hey, is this, you needed a separate desk, a separate area to concentrate. Is that working for you? Do you need anything else? So when it says interactive, it does mean, being interactive in that process.
And just to follow up on what Amber said, that's why job descriptions are so important because you're looking at the essential functions of the job. And if you don't have those essential functions laid out, you're going to step in something you don't want to. And the other thing I was thinking when Amber was talking is training of frontline managers to field these issues and kick them up to HR is essential. Because the frontline managers are the ones, as Lindsay would say, setting that culture of your organization, but they're also the best defense to any claim, and they help you prepare and help you handle these things before they start.
Yeah, and the training burden in that instance is not substantial. It's helping your managers understand what non-magic words or actions or behaviors to be looking for and kick it up to HR where the experts are that can handle the interactive process and other ADA required procedures. Don't put that burden on them. Just tell them what to look for and know how to escalate it. It doesn't have to be, it doesn't have to be an incredible burden.
Right. But Brian, if we go back to the core instruction of what Amber said, is failing to complete the interactive process, failing to complete that interactive process, is that its own legal exposure? So do we have sort of the core claim and you employer didn't follow the steps claim, you didn't dance right? Talk
Yeah,
about that for me.
well, both of those are illegal under the ADA, but at the end of the day, there's only one recovery. So pick the employee gets to pick and choose whichever one is easier to prove up. But from an employer's perspective, you want to avoid both. And you should think of them as one and the same. And the other important point here is by not continuing the dialogue, you're basically losing the defense that you did what you were supposed to do. Because it's very easy for the employee to show, hey, here's a piece of paper. I sent an email saying I need this accommodation, and they didn't even bother to respond. They just terminated me. And I think the other very important point that we haven't brought up yet is you don't have to give the employee the accommodations they request. The employee doesn't get to determine the right or only accommodation. It's what's reasonable and necessary under the circumstances, which again, back to the job description, what is necessary to perform those job duties. And if you're not able to do that, then you aren't qualified for that job position. So that completely alleviates any claim. And you can go ahead and separate that employee.
Yeah. I would add on that point about not being required, the employer not being required to give the employee their preferred accommodation. That's absolutely true under the law, of course. But what I see with my investigator hat on often is that employees get very disgruntled about not getting their preferred accommodation, especially when it's the one their doctor recommends. And so I think the best way, and that puts an employer in a bit more of a tricky position, right? So this goes back to Amber's line about documentation and being real clear about what about that accommodation is unreasonable, what exerts an unreasonable burden on the employee. That's not the right terminology, I don't think legally, but in the instance in which the employer is not going to give them their preferred accommodation, documenting why and having a clear articulation of that ready is going to be really important for the employer.
Yeah, because Lindsay and Amber, I'm sure you've seen more than we have, but Lindsay, you and I have seen some wackadoodle doctor's notes. Gosh, if I could speak to a panel of doctors, I would love it. But I mean, we've seen some crazy things like this employee shouldn't have to come to work on time, should be allowed to leave early, should be able to take breaks whenever they want, shouldn't have to go on screen, shouldn't have to come into the workplace. But no, they don't need to take a leave. They can come, they can work.
Yep,
But do all
right.
those other like dear doctor, have you ever had a job?
Right. But
Any
also the doctor doesn't have any understanding of what the essential functions of the job are. And that's
right.
why an employer has to have them documented.
And again, like commentary, but it's not helpful necessarily to our employers here. Um, what do we do when we're really not supposed to be interacting with the doctor all that much? Um, but sometimes we do just a little bit, or sometimes, can you ask your doctor to clarify? Could you ask your doctor to make sure you're like, just tell us what needs to happen so you can be safe at work, so that you can perform these 12 things that are the essential functions of your job. The team talked to me about how do we engage when we get unicorn sparkle documents from doctors about, you got to give your employee, a unicorn every day to get the work done. How do we deal with that?
The most common time I see this come up is with intermittent FMLA leave. And there is something to be said about allowing the employee time away from work if that's what the doctor recommends. Like if you need time away to get chemotherapy treatment, that's one thing. But it doesn't mean that you're alleviated from the job duties. So you can't not work and claim that it's intermittent FMLA leave every time you need to do an assignment. So it's really hard to deal with this situation as an employer, but it's also very common. And the way you defend yourself is through documentations. You
Yes.
discipline based on their failures of performance, not on their absence.
Yeah. And I mean, it occurs to me just in that moment, Brian, how timing sometimes will work in an employer's favor if they have good documentation of the timing of certain task requests as it coincides with a leave request or an intermittent request, or something that on its face looks protected, but becomes suspicious when you have a pattern of repeated events that coincide in time. The inference of causation works exactly the same way in that instance.
Yeah, and I think we're saying the same thing, Lindsay, but sometimes somebody will get a doctor's note that says if the employer doesn't let you pet a unicorn while you work, you can't do your job. Obviously, that's what you needed. Like that's what the employee hears.
Yeah.
And so suddenly they're failing all the time because a doctor just told them they're failing, and it can get into a real predicament. One of the funniest ones that we seem to always see, and it happens more right in blue collar, hands-on type jobs, but a receptionist needs remote work. Well, you can't remotely open a door very often. You can't remotely be the warm welcome face unless you're on a robot pedestal, or it just doesn't work that way. A manufacturing facility can't handle remote work for its manufacturing hands-on machinery positions. I mean, it just doesn't work that way yet in this world. I am going to interrupt, and because we have a question, and to do that, I'm going to actually pause the recording. Um,
That was a complex one.
um, all right. So Amber and Lindsay too. An employer is already in the middle of a PIP when an employee, or like rolling out a PIP. Like we've been building it. We told you we were going to give it to you. We just haven't given it to you yet. Like we're in the process of rolling out a PIP, and the employee comes back with an accommodation request. What's the first thing the company does, Amber?
So I wouldn't panic, not accelerate the process. I just make sure you document where the PIP stood before the request was made, if you're already in the middle of it. If you haven't issued it, you know that it was there, and then keep it separate as much as you can. Don't talk about it when you're talking about performance because it really is a separate distinction. So you have your performance process, you're following that, and then you have your leave or accommodation process, whatever it may be. And then just that clear timeline showing which event occurred. Continue to apply the PIP consistently. Avoid changing deadlines, expectations, anything like that, because again, it really is a separate
Yeah.
issues that you're dealing with there.
That's really the smartest perspective, is to keep them in their own lanes. And I think the saving thing in this piece is that there's been some, you've at least created some awareness in the employee that it's coming. And so when and if you have to apply the PIP in conjunction or alongside, let's say, their leave or their leave accommodation, that you have that documented in advance, and it's not a surprise.
All right, Amber, we're talking about timing in this call, but we talked about the document being a short, having two sides to it. So this kind of harkens back to our last question, our last session, I guess. When we think we're doing everything right, so we're in this situation where we're about to put somebody on a PIP, but they come back with a leave request. What documentation pattern, what fact pattern of documentation actually looks kind of bad? What makes it look like retaliation? Or maybe it's just the lack of documentation that is what looks so bad.
That is, I think, creating documentation after the fact that appears to justify that decision that was already made, but coming up and doing that, seen that a lot. Um, Inconsistent explanations, from managers, HR, leadership about why that occurred. And the third thing that I really try to drive into people is vague language. A lot of people like to say they're not a good fit. They're not a culture fit. There's, leadership concerns, but what is that? Focus on the behavior, focus on, whatever is happening and document that accordingly. It makes the employer lose credibility, and not because it was wrong, just because the record doesn't explain, what happened clearly.
Yeah, if you guys
Yeah,
haven't gotten the memo yet, culture fit is no longer an excuse for anything.
Right. And in fact,
it's
it's
a
probably going to land you with an EEOC claim.
yeah, it's another way of saying racism.
Yes, that's right. That's right.
Yeah, Amber, one of the things, and Lindsay, I think you'll know why I'm thinking this. One of the things that always plays in my mind is you get these bigger companies and you have one group doing a PIP and one group processing FMLA or ADA, and they aren't necessarily talking to
Right.
each other.
Yeah.
And so sometimes we have documentation happening in different funnels, but when you put it all on one, say, investigative timeline, it looks unattractive for people like
Yeah.
Brian to have to work with then. All right,
Yeah.
guys, let's
Well,
go ahead.
I was just going to add, like Amber pointed out at the very beginning, the very common scenario we find comes to us when our clients are in crisis is they find themselves in these situations where they've made a decision that coincided with some kind of protected activity, and now they have a claim on their hands that they have to deal with. And they're like scurrying. They understand, like most of our clients understand the importance of documentation, but they fail in the execution side of it. And so now they're scrambling after the fact to pull all of those pieces together. And I mean, sometimes the contemporaneous documentation exists and you just have to pull it all together so you can create a comprehensive record of it. But to go back once the deed is done, we're talking about timing, right? Yes, document, but consider the optics of that documentation suddenly materializing in the middle of their leave or after the claim has been made. And so that is a very precarious position for an employer to find themselves in. So the best practice is just to document, have standard protocols for documentation all the time.
Yeah, it's hard when you're trying to run a business.
If your policy has a three-step process and you don't do a warning at all, it may be where you think about holding off till you do give a written warning, or just reevaluate your decision and look at your policy before you make that ultimate deployment decision.
Yeah.
All right, let's do a little pivot to our multi-state employers because it's so easy to be jurisdictionally agnostic anymore and hire people in other places. Um, Brian and Amber, I'm looking at you guys. If we're a Texas employer and we go hire somebody in Colorado or just wherever else, we start to avail ourselves to being subject to additional state laws. And they can have different timing obligations on their things. Texas has different timing on some of its discrimination claims, just to call our own selves out. Brian, what is our legal exposure when we have states with different timing?
Well, it increases your legal exposure,
Hmm.
and it also increases the size of your handbook when you're jurisdiction agnostic. You have a lot of extra sections in your handbook, but you need to be versed on those other states' laws. You need to have a process in place to check where the employee is located. Are there specific laws in that state? I know in Texas, we have a 180-day requirement to file a charge of discrimination, whereas on the EEOC for federally, it's 300 days. So if you want to file a state law claim in Texas, you need to file that EEOC charge in a shorter amount of time. And so that's just one example from here. I know there's quite a few other examples that those others on the call that are more versed in different states would know.
I
Amber,
think,
yeah, go
oh,
ahead.
sorry. Yeah, I think for me, being someone who's, run an HR department that has been in 40 different states at the same time, I think understanding if you have someone in, it could be Colorado, it could be California, Washington, New York. I mean, every state's trying to be a little bit different, whether it's, training, accommodations, leave, and they'll run concurrently with FMLA, and they might cover one little extra thing or not cover. And so being aware of that and these notices, and it's really kind of crazy how different the states are. So being aware of those and checking every time you get a leave request with, from a state, do they have it? What are the requirements? What's the differences? Because it's kind of overwhelming a little bit, once you realize all the different things in the states.
And the handbooks are bigger.
The handbooks are huge, yes.
And what'll happen is you have one state that's very similar to another state, except for one small area, and that's where you get caught.
Yes,
What was
absolutely.
it, Amber? We had a client that insisted they be jurisdictionally agnostic, like insisted on it, and their handbook was like 650 pages. Um, yeah, it just gets to be crazy. Okay. Everybody, what is one thing that we could do, that our clients could do to be more time aware, to have better timing of our documentation, and just generally to have better awareness of the clock that's ticking on anybody's employment situations? What's one thing that can land with our clients? Brian?
Document better.
Whatever. What's one thing they can take back is just document better. Amber, what do you think? Brian probably
I
took yours.
think making sure your manager's looking at what trainings you've done, say in the past year, to and see if you need to maybe invest in a training.
What you got, Lindsay?
This is going to be for folks who maybe haven't had the burden of a claim come to them, so they haven't known to look for patterns and practices within their own within their organization. And so a file audit can sometimes be revealing of something that's happening or creating suspicion that you don't know about. So looking at, taking your stack of files for anyone who's had any protected leave lately and checking to see if there's any aligned protected activity, to see if there's any kind of patterns that you're detecting that you can intervene in before they become escalate to a claim.
Can I get one more?
Sure.
Oh.
Go talk to your people in the field and see if your policies and procedure handbooks need to be updated to match what's actually going on in your organization.
Yeah.
Yeah. All right. I gave everybody permission to talk. It looks like Michelle's already figured that out. We're at time and we're out of the questions that we said we were going to talk about. What do you guys got? Michelle, you got something else?
Not really. I just appreciate you guys addressing my question earlier. So yeah, I mean our handbook covers, the attendance, like you talked about, and it also has a zero tolerance substance abuse policy in our handbook as well. So, as far as, stimulants and, depressants and everything, and alcohol falls under that category. So it doesn't specifically mention it, but it is a suppressant. So, yeah, it's just a tricky situation, one that we're not looking forward to dealing with when she returns, but
Michelle, one thing I'd also add to that conversation, it sounds like maybe this is the first time you've dealt with this precise sort of complex situation, but in the event you've had similar situations in the past, I would just remind you, and I'm sure you know this, to make sure you're being consistent with what your past practice has been as well. And if you're going to deviate, document why you deviate.
Yes. Thank
Michelle,
you.
are you going to wait until she returns?
Well, yes. I mean, we can't terminate her while she's in rehab. So
I think you should reach out to counsel, please.
I'm sorry.
I think you might want to bring in an attorney to help you guys out.
Okay. All right.
All right. If nobody has any other questions, I am going to tell you all have a really great Thursday and stay cool. It's so hot here. But I appreciate this. This is so much fun every single month. I love doing these, you guys.
My favorite thing.
Thanks, everybody.
Bye,
Thank you.
everybody. Thanks for coming.